like many other laws of its kind, this law is designed to eliminate wage gaps by stopping the perpetuation of prior salary history discrimination. By removing the question of an applicant's salary history from the hiring process, the hope is that the applicant will be analyzed based on their individual skills and experience rather than their prior salary, which could have been affected by discrimination. The New York City salary history ban is certainly similar to this California law, but there are some key differences. In California, employers will be required to provide, upon reasonable request, a pay scale to applicants for the position. While the New York City law certainly contemplates having discussions about salary expectations, this requirement to affirmatively provide a pay scale is certainly something different from the other salary history inquiry laws. Another key difference is that the California salary history inquiry law reaffirms a part of the California equal pay law, which prohibits employers from justifying salary discrepancy based on prior salary history alone. Thus, while employers in California may consider voluntarily disclose salary history information, they may not rely on prior salary history alone to justify any pay discrepancies between workers of different genders or ethnicities who are performing substantially similar work. This requirement does not exist in the New York City law. Additionally, the New York City law allows employers to ask applicants about their deferred compensation and pay equity that they may be giving up in order to change jobs. The California law does not have this exception, and it is unclear whether this will be permissible in California. Employers will need to act quickly before the effective date on January 1st of 2018 to make sure that they are complying with the law. Employers will need to revise employment applications as well as any other forms that are used during the hiring process in order to remove questions about salary history. Employers will also need to take steps to train anyone who's going to be interacting with the applicants, including human resources staff, managers, and anyone else who may interview the applicant to make sure that they understand the requirements of the law and that they are not actively or even inadvertently seeking salary history information, and that any disclosure done by an applicant is made on a purely voluntary basis without prompting. When an applicant does decide to voluntarily disclose information, employers should take steps in order to contemporaneously document that information and the circumstances of the disclosure, as well as to adopt a procedure by which they are consistently documenting such disclosures. Externally, employers will also want to take actions to ensure that the vendors they're working with, such as background screening companies, recruiters, headhunters, are complying with the law. To that extent, employers may want to amend the agreements that they have with those external vendors in order to put them on notice and require compliance with the law, and also to seek indemnification for any claims that may arise against the employer for that third party's failure to comply with the law.